executives of businesses who have this primary duty must also exercise due diligence to ensure the business complies with the duty. So if you're a business owner or a senior manager, it's highly likely that you will be caught by this duty. So the key changes that have been made, these duties are already there in the Heavy Vehicle National Law now, but they've become positive, proactive duties. So the primary duty is now risk-based, not outcome-based, so no longer requires a road offence to be committed by a party to be found in breach of that duty. And it's the same way with executive officers as well. And in both cases, the burden of proof returns to the prosecution, whereas currently the defendant must prove that they took reasonable steps, or if in a case of an executive, that they exercise reasonable diligence. So this change actually will have more of an impact on how regulators investigate potential offences. So to start out with, it's important to know whether you're actually captured as an executive under these duties. So the concept of personal liability for corporate fault is not new, and it's a feature of quite a lot of laws. And this is because a company is an artificial entity and cannot make decisions or act other than through individuals. So there will be offences specifically for individuals. Now, the Heavy Vehicle National Law recognises three types of entities: corporations or companies, unincorporated partnerships, and other bodies, unincorporated bodies such as, for example, sole traders and family trusts. So individuals that have personal liability for the conduct of these entities are, in the case of a corporation, what they call an executive officer of a corporation, so that could be a director, or any person who is concerned or takes part in the management of the corporation. In the case of an unincorporated partnership, it's a partner, and for an unincorporated body, it's a management member. So liability for corporate fault is generally aimed at the people who are the controlling minds of a company or business. So it's those people who make decisions on how the business is structured, how money is spent, its policies and procedures, rather than the people who manage the day-to-day operations of the business. So in a small business, that could be the same person. So an owner-operator would very well be there at the coalface. They would have the duties of an executive. But in large businesses, the officers or the executives may be more removed from the day-to-day management. So these could be directors on boards, in large organisations. But in some cases, it could also be senior managers as well. So not just CEOs, but people who are right at the top of the hierarchy and actually will be involved in making decisions on how the business is run. So whether you are an officer or an executive will depend on your role in the business and not on your title. Excuse me. So you need to ask yourself if you have authority over how the business is run, its finances, recruitment decisions, purchasing decisions, and how risks are managed. So there are two situations currently in the Heavy Vehicle National Law in which an executive officer may face liability for a listed offence. So that's where the executive officer actively authorised or permitted the offence, or where the executive officer knew or ought reasonably to have known of the conduct constituting the offence, or knew or ought reasonably to have known there was a substantial risk that the offence would be committed. So the Heavy Vehicle National Law lists specific offences. These are all in Schedule 4, and they include things such as using an unregistered vehicle, making false or misleading statements, contravening a heavy vehicle standard, allowing a driver to drive while impaired by fatigue, and these are all offences which will attract executive officer liabilities. Now, the current situation is that you're only liable if the company has committed an offence. So this is something that will change with the new duty. It won't rely on the company committing the offence, but at the moment it relies on the company first committing the offence. and then you're automatically liable. And the onus is also on the defendant to prove that they exercise reasonable diligence to ensure compliance. So these liabilities also apply to partners of an unincorporated partnership and to management members of an unincorporated body. So what has changed in terms of the new duty? So the new duty only applies at the moment to the primary duty, so to that chain of responsibility duty that I mentioned at the start. So it says that if a legal entity has a primary duty, an executive of the legal entity must exercise due diligence to ensure the legal entity complies. So the legal entity are the corporation, the unincorporated partnership, and the unincorporated body. So still those same three legal entities, and I'll explain what we mean by due diligence shortly. So this is it's a positive duty, and it applies continuously, not only after a contravention by the company. Making an officer responsible for their own conduct in this positive, proactive way is aimed at giving the officer more control over their personal liability, and is seen as providing more fairness as well, instead of automatically making officers guilty when a company has committed an offence. And that's sometimes called attributed liability. So further to this new provision, which applies to the chain of responsibility duty, the existing section 636, which is the current duty for executives, it's still there, but it has been changed. So it's been changed from a deemed liability offence with that reverse onus that I was talking about to a positive, reasonable diligence obligation. So in deciding if the executive officer exercised reasonable diligence, the court must have regard to whether the officer was in a position to influence the corporation's conduct and the action the officer took or could reasonably have taken to prevent the conduct. And this one, again, as I said before, applies to partners of an unincorporated partnership and management members of an unincorporated body. So this duty still exists and applies to those specific offences that are listed in the Heavy Vehicle National Law. So these changes are modelled on the provisions of work health and safety laws. So if you have duties as an executive under the Heavy Vehicle National Law, you will also have duties as an officer under work health and safety laws. So there is a slight difference in the definition under work health and safety laws. In terms they mention an officer, and it's the same definition that's used in the Corporations Act. So it applies to people who are making or participating in making decisions affecting the whole or a substantial part of the business. Now that is a slightly narrower definition than the one in the Heavy Vehicle National Law, which is about a person who's concerned or takes part in the management of the corporation. So there's often a question about how far down in the management structure does the duty go. But there have been quite a few court cases around the definition of who is an officer, and I'll go through one of those later on in the presentation. So there are three aspects to the definition of due diligence. The Heavy Vehicle National Law defines due diligence in the same way that it's defined in the work health and safety laws. So it's basically about having individual knowledge. It's about understanding the management of the business and ensuring that the business is managed properly and that risks are managed. And it's about checking and assuring compliance. So firstly, if we talk about the knowledge aspect, the definition requires that executives need to keep up to date with safety issues. Being informed will help you make the right decisions. So this means being informed about regulatory changes, industry safety practices, and technological developments. Executives need information from various sources, so within your business, from your managers, from employees, as well as from outside your business, so from people in your supply chain, subject matter experts, and regulators. Understanding the nature of the operations and associated risks is also one of the elements of what due diligence means. And this tends to be easier for executives in smaller businesses because they're closer to the coalface. But for someone in a large business who's not involved in the day-to-day operations, they may need to take extra steps to actually ensure that they understand what the business does and how it operates. They may need to make regular site visits, for example. They may need to examine health and safety reports. They may need to obtain information on the type of risks the business is exposed to and how these are being managed. So the second aspect is to ensure resources and processes are available and used to manage risks, to receive and respond to information on incidents, hazards and risks, and also to ensure compliance with legal obligations. So you need to think about what steps are taken to identify hazards and assess the risks in your business. What resources do you apply to safety in terms of people, time, money, training? Are those resources applied proportionate to the level of risk? And if you're cutting costs, how is that affecting safety? It's important to set up a safety management system, and you'll hear the National Heavy Vehicle Regulator talk about this quite a lot when they talk about the new chain of responsibility duties. And also make sure that your business has got policies and procedures that you've developed in consultation with your workers, and ensure everyone understands and follows them. Have a process for communicating information about hazards and risks and any changes to the operations up the chain of responsibility and back down again. Collect information on incidents, hazards and non-compliance in the business, and make sure you're getting an accurate picture of the safety performance in your business. And that can help you, and it can also help if you actually encourage no blame reporting, where people and your workers are prepared to report their errors and near misses. And also be aware that if you're providing any incentives based on performance measures, such as lost time injury rates, that can actually encourage underreporting. Think about whether your business has identified all its legal obligations and what processes you have in place for addressing breaches of the heavy vehicle national laws as well as work health and safety laws. And then most importantly is the assurance part. So you need to check that the resource and process that you've implemented are actually provided and used. So think about whether the processes for managing risks are effective. And in a risk management system and in the process, there's always a review step, which means that you have to look at whether the measures you've implemented are actually working. How do you monitor that your business practices and those of other parties in the chain of responsibility do not cause or encourage the driver of a heavy vehicle or another person to contravene the heavy vehicle national law or the driver to exceed a speed limit? Do you challenge or question the information you receive? Do you ask for evidence? And do you test or audit procedures? So these are all important ways that you can ensure that you are meeting the due diligence obligation. So now I'll just go through a couple of court decisions around the duties of officers or executives. There have been many prosecutions of officers under work health and safety laws, but most have involved directors and senior managers of smaller companies. And this is generally because they're more closely involved in the work activities and it's possibly easier to prove that they breached the duty. So these cases set precedents for who is an officer or an executive and what due diligence requires. So both cases have come from prosecutions under work health and safety laws. And in this first example, a company in the ACT was prosecuted for failing to ensure the safety of a delivery driver who was electrocuted when his vehicle touched power lines at a construction site. The project manager was also charged as an officer over the fatality. The magistrate found that the project manager had failed to exercise due diligence, but he was found not to be an officer because he only had operational responsibility for the delivery of specific contracts and not responsibility for the company as a whole. So the magistrate found that the manager sat close to the top of the structure of the business, but the business had a relatively flat management structure and there was no evidence he made or participated in making decisions that affect the whole or a substantial part of the organisation. So that goes back to that earlier definition of an officer that I talked about. He also found that the manager identified potential employees but wasn't responsible for hiring or dismissing them. he didn't have the authority to commit corporate funds to projects, and he prepared tenders, but he didn't actually sign off on them. So the manager was acquitted of those charges. Now, the company was a family business with decisions made by a husband general manager and a wife director, but they were not charged. So if they had been charged as officers, it's likely that prosecution may have been successful. In the second case, which is also unfortunately an electrocution of a 13-year-old boy, the company which operated a hotel pleaded guilty to a failure to keep the premises safe in circumstances where the 13-year-old boy was electrocuted. 3 relatively hands-off directors were also charged, but they pleaded not guilty on the basis that they were not involved in the day-to-day running of the hotel. Instead, they had appointed experienced managers to run the business. Prior to the fatal accident, they did not hold any board meetings to discuss occupational health and safety issues at the premises. They believed that there was a safety system in place at the premises, but that management had a responsibility for that. As directors, they provided no input, nor did they play any role in the management of the system. They did not require the managers to report to them on health and safety, and did not implement any processes to ensure the managers were correctly addressing safety problems. So the court found that although the directors were entitled to rely on others who possessed relevant experience and expertise, they had failed to make consistent and ongoing inquiries to ensure that management was both capable and competent of discharging this corporation's obligations. So this comes back to that due diligence part of the definition where I talk about assurance processes and being able to check and verify that what the business should be doing, they are actually doing. So just in practice, an example here of the due diligence obligation in terms of the chain of responsibility duties. So you've got a company called Truckload Transport. They will have the duty as a party in the chain of responsibility as an operator. So they have to ensure the safety of the transport activity so far as reasonably practicable. And then you've got 3 directors of that company who will be the executives. So they need to exercise due diligence to ensure the business complies. So under COR, there are a whole lot of things that you will need to ensure in relation to load restraint, vehicle mass and dimension, fatigue. And in this case, the executives will have a whole lot of things that they need to do to check, for example, that procedures are being followed, to ensure that systems are in place to manage risks, to keep up to date with transport safety practices and developments in the industry, to develop policies and procedures relating to, for example, scheduling, loading, unloading, fitness for duty, site rules, etc. And also to arrange regular audits and check compliance. So in relation to the chain of responsibility duties, it's not about taking on the obligations of others in the chain. You're not expected to run another person's business for them. But due diligence does involve asking the right questions of the people that you work with in your supply chain, and in effect looking over their shoulder to ensure that you're reasonably satisfied that the people you deal with are aware of their obligations and compliant in their operations. So there are penalties, new penalties under the chain of responsibility duties. The maximum penalty for executives is the same as the maximum penalty that would apply if the breach of the duty had been committed by an individual. So there are 3 categories of offences, and again they are based on how offences are categorised in work health and safety laws. So the first category is the most serious one. So you have, this is for where a person engages in conduct that recklessly exposes an individual to a risk of death or serious injury or illness without a reasonable excuse. So you can see for a corporation the maximum penalty is $3 million. For an individual, it's $300,000 or 5 years in jail. 3 years in jail. 5, sorry. So the individual penalties are the ones that apply to executives in the case of the heavy vehicle national law. For Category 2, that penalty applies for persons who contravene the duty and expose someone to risk of death or serious injury or illness. And for Category 3, which is the least serious one, it's just where a person contravenes the duty. So there doesn't have to be necessarily a risk of exposure to death or serious injury. And remember that the chain of responsibility duty also applies to not only harm to individuals, but also damage to infrastructure. So the officer penalties for officers under work health and safety laws are actually twice as much. So in relation to Category 1, it's $600,000 or 5 years in jail. For Category 2 offences, it's $300,000 and $100,000. So yeah, double as much as in the heavy vehicle national law. So just finally, safety performance measures are really important because it's essential that executives remain informed on how the business is performing. There's no standard set of performance measures for the transport industry, and it will depend on the type of business you have. So you can develop a set of indicators. They're sometimes called KPIs or key performance indicators, and they're basically two types. So you can have lead indicators. These are the ones that measure the inputs, and then you can have lag indicators which measure outcomes. So lead indicators really measure how you're implementing safety, and the lag indicators will measure the effectiveness of that. So examples of lead indicators are numbers of audits and inspections that you're doing, the numbers of policy and procedures you have, the amount of training you're providing, attendance at training. So these are all of the proactive measures that you need when you're actually managing risks. And lag indicators is looking at the outcomes. So how many incidents, injuries and illnesses have you had? It's also looking at fines that have been issued to the business, workers' compensation claims and lost time. So it's important to really have a mix of both of those indicators. And just finally, takeaways from today. The due diligence requirements recognise that effective safety management starts at the top with an organisation's leaders, and the reframing of the provisions in the heavy vehicle national law to positive duties means that executives need to be much more vigilant and take an active interest in what's going on in the business, and also have a really good sense of curiosity, and as I said before, ask questions, make sure that you get an accurate picture of what's going on in your business. Think about how your decisions influence safety outcomes. Do you have all the information you need to ensure you can exercise due diligence? Ensure systems are in place to manage risks. And also remember, you cannot delegate your duties. So even in a small business, you might have a husband and wife director, or you'll have directors on a board. So each of those will individually have the due diligence responsibility, and the extent of that will depend on the role that they have in the business. And that's the end of the presentation from me. Thank you.
Great. Okay, so for more information on today's webinar, we have recorded the webinar today, so we will send out an email following today's presentation with the webinar recording as well as the presentation handouts if you'd like a copy of those. If you are a NatRoad member, Julia is available to provide complimentary information over the phone, so please do give us a call. If you're a non-member, please remember you can access all this sort of information free of charge. If you're interested in finding out more about the benefits of becoming a member of NatRoad, please call us on 1800 272 144. We'd now like to go to questions. I don't have any questions that have come through as yet. But if you have any questions, please don't be shy. As you can see, we've got a little example on the screen where you can pop your questions in for Julia. We'll wait a few minutes for questions to come through if anybody has any. If we don't get any questions, we'll end the webinar in a few minutes. So please do send them through if you have anything regarding today's webinar. Look, it doesn't look like we're going to get any questions today from the audience. That's okay. If you do have anything on the mind and you'd prefer ask them privately, you are welcome to send Julia an email, as mentioned, or get in touch over the phone. We'd love to know what you thought of today's webinar, so you'll be given a short survey when you close out today, and we'd really appreciate it if you could take a few moments of your time to tell us your thoughts. It is only our second webinar in the series, so we're constantly looking to improve and make sure that our webinars are nice and useful for you. That's all we have for you today, so thank you again for coming along, and we'll see you at the next webinar.